I am the president of the UB Law Alumni Association's Gold Group. Thank you for attending today's CLE presentation, Estate Planning Basics. This is one in a series of many virtual programs from the Law Alumni Association and the Gold Group, hosting as a service for our alumni and law students. If you're interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website, law.buffalo.edu/alumni events, and we'll put that link in the chat. You can also listen to past CLE and other webinar recordings at no charge on our new alumni education page, also located on the law school website. To get discounts and select a free 1-hour CLE, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. Finally, I'd like to thank our Gold Group sponsors who have helped underwrite the costs associated with these events and lots of the other fun things that the Gold Group does throughout the year. Our sponsors include Chicago Title, Council Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution Paramount Settlement Planning. A few brief administrative points for everyone. You will be muted during the course of the presentation. If you have a question at any time, please use the chat room and we will try to address the questions cumulatively at the end. At some point during the course of the CLE, the course code will be announced and will also be placed in the chat room. Be sure to catch it, as you will need to put it on the online attorney verification form that was included on the registration page. This form is required to issue you your CLE credit. Please also return the program evaluation form found on that page. And that's all I have. I think Emily and Earl,
Yep.
Are you?
I got it, Sam. Hi, everyone. Good morning. My name is Emily Rudroff, and I'm a 2015 graduate of the law school and co-chair of the education committee this year with Earl Cantwell, who's also on today. It is my great pleasure to introduce our speaker, Lisa Allen. Let me just pull up her. Lisa is currently the owner of her own private practice, the law office of Lisa J. Allen, where she is the supervising attorney of a professional legal staff of 8 attorneys and paralegals. She focuses her legal practice on trust and estates, elder law, and disability advocacy, including issues related to Medicaid eligibility, guardianships, supplemental need trusts, long-term care planning, estate planning, and the probate and administration of estates. She is a frequent community lecturer on issues affecting elderly and disabled individuals at continuing education courses for financial professionals, accountants, and attorneys. Ms. Allen is also an adjunct instructor at the University at Buffalo School of Law, and she was a prior supervising attorney for the clinical legal program in special education law at the law school. I will now turn it over to Lisa. Lisa, thanks for being here today.
Thank you. Good morning, everyone. So I do this seminar actually very frequently, and I usually start with a story because I find that teaching these types of things are often illustrated better by the things that people do that are mistakes rather than the things that people do that are just written in the rules. So the biggest problem that I usually encounter when I'm talking to community groups and trying to explain to them what estate planning is and why you should do it and what happens if you don't is that they don't understand usually the difference between probate property and non-probate property. And even a lot of attorneys don't understand that, because I have quite a few clients that are attorneys that come into my office and are a little bit confused about it. So and I know that the materials are uploaded. I think that you all can print them, but I'm not going to put them up on the screen because I want to talk about the common estate planning mistakes. And so you'll notice that there's a form that goes into a little story about a client of mine named Mary. And Mary is just a compound of many clients that I've seen over the years and their kids. And so Mary is a client who had a very simple will that said that she wanted to leave everything to her 5 children in equal shares. And there's a will that said that. And after Mary's death, the 5 kids come into my office. And I can almost always tell which kid is which by what side of my conference table they're sitting on. Well, the fact situation in this particular hypothetical is that Mary had some assets that totaled around $200,000. She had $100,000 in various accounts. However, they were joint with her oldest daughter, who was actually taking care of her finances as she grew older, and that she had a house worth $100,000. The house, which was in her name alone at the time of her death, is actually the only probate asset, because the $100,000 in accounts at various financial institutions are all joint with the oldest daughter only. So here's what usually happens when these family members come into my office. You've got 4 kids sitting on one side of the conference table saying, Mom wanted us to share everything equally. And they're all mad at the oldest daughter. Because the oldest daughter, actually, even though the will says I leave everything to my kids in equal shares, is actually going to receive the $100,000 in the joint accounts that were open with her, plus 1/5 of the sale of the house for $100,000, which means that the oldest daughter will get a total of $120,000 of the $200,000 estate that Mary left. And 4 other kids will only get $20,000 apiece. So now this is always puzzling to the general public when you're telling them this story. And the question often becomes, well, were these joint accounts one of convenience, or did the mom intend to leave all of the joint accounts only to the oldest daughter? Well, adult children always seem to assume that the parents have to leave everything in equal shares, meaning every child should get an equal dollar amount. And that hardly ever happens. Although I have been involved in many litigation situations in surrogates court where people allege that joint accounts held with one of the adult children was actually only a convenience account. And so one of the things that I like to stress when clients come into my office is that if they do plan on leaving non-probate assets, like a life insurance policy or an investment account with a transfer on death designation, or a jointly held asset to one of more than one children, that they put it in some kind of a writing. So my office frequently drafts what we call a distribution of estate proceeds agreement. And it's not a form that you'll find in a form book, because what we actually do is sit down with the clients and ask them, what is your intention? I think that what happens with a lot of estate planning attorneys is that they don't bother to sit down and explain to their clients that many of their assets are not going to go through the will at all. In fact, in many situations, the best case scenario is that even though you've drafted a last will and testament, it's going to be totally superfluous. Because obviously, if an asset passes because it has a beneficiary designation or a joint owner, that's going to be a lot simpler than actually having to probate a will. And so many times what we'll do is we will go through a list of what the clients actually own, and each asset will identify, does it have a beneficiary designation? Does it have a joint owner? Is it something that you want divided among all the kids, or is it something that you want to leave to one child in particular? And there's no right or wrong answers to those questions. It just depends on whether or not the parents want equal pecuniary amounts of assets to go to each of the children, or if they do want to reward one of the kids. So the situation in my hypothetical with Mary, which is on that form that I put up with the materials, in that situation, a lot of times the decedent actually did intend to reward one of the kids. I've found in my practice over the last 35 years that a lot of times it'll be one of the kids. For some reason, it ends up a lot of times being the oldest daughter. But there is usually one child out of the many children who has given up a job or has had the elderly parent move in with them, or has been the one that has been taking mom to all the doctor's appointments and you know, cleaning out the refrigerator and getting the house ready for sale, and you know, has given up considerable time and effort, while maybe the other 4 kids don't even live in the Western New York area. And so you really need to ask the client, what is your intention? Do you want to reward one of the children for having spent extra effort and time? If you listen to some of the arguments that the adult children get in my office when they come in with a will, it's kind of indicative of what's been going on. I mean, the arguments center around whether or not the kids that lived out of town actually spent enough time taking care of mom to deserve to get an equal share of all of mom's assets. And of course, that's not really our role as attorneys to determine the testator's intent after their death. It's our role as counselors to try to find out what their intent is before they die and when there's still a chance to do something about it. So I've included in the materials just the format for a very simple will. And usually you'll see that, especially with married couples, the format is it's the usual format that we call a sweetheart will. If you're doing wills for a married couple, usually the husband leaves everything to the wife leaves everything to the husband, and then typically you will see a provision for equal shares to the kids, and if any of the kids predecease a testator, their children, the grandchildren, get their share. And in that case, it's normal that you would put in some type of a trust provision for the grandchildren. So here's another area where I find that a lot of people skip over some of the steps. When you're drafting a will, and if you have clients who either still have children who are minors because they're a young couple, or if you have clients who have grandchildren that are minors and they're establishing a testamentary trust for those kids, usually you'll sit down and you ask them a bunch of questions about, well, what do you want the money used for? If it's held in trust for a child or a grandchild, is it primarily to be used to pay for higher educational expenses? Is it just to be a fund to give them a better start in life so that they have some money to fall back on if they need a down payment for a first home purchase, or if they need it for emergency medical or dental, or if it's going to be used just to enhance their quality of living, or if it's actually intended for health, education, maintenance, and support purposes. You kind of want to get a feel for what the intention of that money was. And so you can draft very detailed provisions inside a testamentary trust and a will regarding what the money is to be used for. And usually you're going to also put in provisions about when the trust beneficiaries can get the money outright. I typically tell my clients that they probably shouldn't make that age any younger than 25, only because if you're establishing a trust for a younger person, probably want it to be in the trust long enough so that it wouldn't interfere with their ability to get financial aid as an undergraduate or a graduate student if they do go to any type of higher education institution. And so typically when I draft those types of trusts, I put in provisions that requires the trustee to exhaust all other sources of financial aid before making distributions from the trust for educational purposes. We've had some instances where, in particular, when a child or grandchild is filling out a FAFSA form for college aid, where the question is, are the trust funds available to meet college expenses? And so some of these trust provisions can actually get fairly complicated. But then the biggest mistake I see is that when a parent or a grandparent dies and assets are actually ready to be passed into this trust for the child or grandchild, a lot of times, many of the assets, again, have non-probate designations. So I might have drafted a really detailed trust for a minor child in the dad's will, let's say, But then when the dad dies, he has life insurance and a retirement account and an investment account. And the beneficiary is the words, my children in equal shares. Or if it's a grandparent, the words, my grandchildren in equal shares. Which means that it's not going to go to this very carefully drafted trust that you set up inside the will. Because even though you have all of these very detailed provisions about what the money was intended for and how long it's supposed to be held and when it's supposed to be distributed to the trust beneficiary, unless you instructed your client to go back to all of the financial institutions where they have non-probate assets and get a change of beneficiary designation form, where they actually are going to change the beneficiary from the words my children or grandchildren to the words to the testamentary trust created under my last will and testament for the benefit of my children or grandchildren, that money is not going to go into the trust. And I can't tell you how many times in the 30 plus years that I've been a practitioner in this area that I've seen that happen, where you have these trusts that were created in a will, but then your client on later filling out beneficiary designation forms did not designate the trust as the beneficiary of their assets. And so what typically happens in that situation is if the children or grandchildren who are receiving the non-probate asset in equal shares are minors, are under the age of 18, then even though now you've made it a non-probate asset, so supposedly you've avoided any surrogates court involvement, if the beneficiary is a minor, you're back in surrogates court again, because nobody can take a non-probate asset for a minor unless somebody applies to the surrogates court to be designated as the guardian of the property of the minor beneficiary. So then what happens is now you're filing an Article 17 guardian petition in the surrogates court, asking the court to nominate and appoint someone as the guardian of the property of the minor. And so all of these non-probate assets that your client probably presumed would go into the trust that they drafted in their will are now going to go into a guardianship account that's going to be held jointly with the guardianship clerk of the surrogates court, which means that not only are the guardians of the property of that trust beneficiary going to have to file an accounting every year showing how much money is in that guardianship account, but two other things are going to happen that are detrimental. One is that in order to get any money out of that type of an account, the guardian has to file a very long and complicated petition for withdrawal of infants' funds. And the surrogates courts are notoriously stingy when it comes to approving the use of a minor's funds before they reach 18 years of age. Their primary objective is to preserve that money, hopefully with the intent that it would be used to pay for college expenses or other expenses after the child reaches adulthood. So I've seen many petitions requesting withdrawal of minors' funds in guardianship accounts be rejected. For instance, it's not uncommon for them to reject applications to pay for high school tuition at a private high school, which always causes a lot of clients to be surprised. But the surrogates court doesn't feel that they should use that money necessarily for secondary school expenses. They want it preserved for college and graduate school expenses if possible. The other thing that they almost never will approve, and I see people apply for it all the time, is the purchase of a vehicle for a 16-year-old who now has a driver's license, even if they have a job and need it to get to a job or school. The surrogates court is unlikely to approve an application for the purchase of a vehicle. So those and sometimes they get the petitions for withdrawal can become complicated because many times a guardian ad litem, a second attorney to represent the child, has to be involved in the court appearance requesting the withdrawal of infants' funds. The other thing that happens though, when money goes into a guardianship account, even though you've drafted a very careful testamentary trust, is that the kid can get it back at the time of their 18th birthday, which if there's any age at all that you wouldn't want a person to receive a large inheritance, especially if they're going to go to college or grad school, is on their 18th birthday. Because if they do get the remaining funds in a guardianship account and are filling out the financial aid form for aid for college or secondary or graduate school attendance, all of that money is going to be deemed available resources to the student. So I've seen many cases where it has completely made them ineligible for any financial aid if they go to any type of a university that requires a family contribution towards the tuition. So you have to be careful when you're counseling your clients about the difference between probate and non-probate assets, because it can come back to haunt you. And in many times, the distributions that result because of the non-probate designations will completely throw off the testamentary scheme that the client intended. Those distributions of estate proceeds agreements that I draft usually have to do with situations where there are certain non-probate assets that we're leaving to one child for a specific reason. So I've also included in the materials, but I did send it in a little bit late, so you might have to print it off after the seminar today. There's some language that I used when we do what's called a deed transfer with a retained life estate. So I, in addition to doing estate planning, I do quite a bit of elder law planning. So much of my focus when I'm doing my estate planning is on trying to set up people's estate planning documents so that if they do need long-term care as they grow older, we have the necessary documents to do Medicaid planning. Well, one of the things that we use as a frequent tool to protect people's assets is if a married couple or a single individual owns their own home, you want to consider deeding it over to one or more of their children and having your client retain a life estate, meaning they own the house until the day they die, but they're giving away the remainder interest, which if you go back to your first year in property, the remainder interest is the ownership of the house from the life tenant's date of death onward into perpetuity. So I have provided the language that we use on those type of deeds. But here's one of the considerations, again, that many people fail to take into account. When people come to my office and they have 3, 4, 5, 6 children or more, the question is, should you deed over their house to all of the kids on the deed, or should you just select one of the children to be in charge of selling the house after the date of death of the last parent to die, and then splitting the proceeds with their siblings? And again, this is one of those questions where there's not necessarily a right or wrong answer. It's going to depend on what your clients intend. But here's some of the considerations that you as a legal counselor want to take into account. When you do a deed transfer with a retained life estate, which is done by deed, that has to be recorded in the county clerk's office, you actually are going to prepare and record all of the same documentation as if you were doing a sale to a third-party purchaser. So you're going to do a new deed, usually from mom and dad to one or more of the kids. You have to do an equalization form. You have to do a gains tax affidavit. You're going to do an application for exemption from any transfer taxes, because there's typically no money changing hands in these situations. So you're going to do a lot of preparation of real estate documents. The deeds for a life estate transfer are usually from, again, mom and dad, or if it's a widow or widower, the survivor of a former joint tenancy, to either all of the kids or sometimes just one of them. And so the reason that you might want to limit it to just one of the kids, even when there are multiple children, is because once somebody's name is on a deed that's recorded in a county clerk's office, it's a matter of public record. And it is actually an ascertainable asset. It has a value, even though it's not vested yet. And so when you do that deed transfer, the owners of the residence are going to retain ownership until the day they die, which is called the life estate. And what happens is then their ownership is not equivalent to 100% of the fair market value of the house. There are actually actuarial tables that are published by the IRS that will tell you for any given month of any given year what the value of a life estate interest is worth and what the value of a remainder interest is worth. It's kind of interesting because those tables of what they're worth are calculated depending on what the federal midterm rate is for the month that you record the deed. And so our interest rates lately have been going up, which causes the value of the life estate interest to be worth more than it normally would be. For those of you that don't do real estate on a regular basis, what happens is when you do this type of a trust, the life estate interest and the remainder interest are valued at reciprocal percentages that have to add up to 100% of the fair market value. Okay. The easiest way to explain it to a client or to understand it yourself is that the older the life tenants are getting, the closer they're getting to their date of death. So every day their life estate is worth a little bit less because their remaining interest, which is measured by their lifetime, is 1 day less. So if, for instance, a life tenant's interest is worth 20% of the fair market value of a house, okay, that means that the remainder interest that the children own after you record this type of a deed would have to be worth 80%. Every year then, as the life tenants get a little bit older, the value of the life tenancy goes down a little bit. So then the next year, if it was worth 20% the year that you did the deed, the next year it might be worth 17 or 18%, which means the remainder interest then went up to 83 or 82%. The two values always have to add up to 100%. And so one of the things that you want to do when you're preparing those documents is talk to the clients about whether or not they want all of the kids on that document. And again, I'm just going to tell some stories that illustrate why it's important because of things that went wrong. So if one of the kids who's listed as the remainderman on the document, meaning they're the person that would get it after your clients die, if they're on the deed and one of three things happens to them, then your clients could have some issues. First is if one of the remaindermen is going to go through a divorce where equitable distribution is going to be an issue because the remainder interest has an ascertainable value, even though it hasn't vested yet because the life tenants are still alive, it's worth some amount of money. So it could be an issue if a remainderman is going to get a divorce. The second is if they get sued for any reason. A remainderman rear ends a car and now is involved in a lawsuit where they've been served with a summons and complaint, and there's a possibility that a judgment might get taken against them. That might be an issue. The third and the biggest one that we see the most often is the remainderman is going to file a petition for bankruptcy. Okay. If any of those three things happen while they're on the deed to their parents' house, even though they have not yet vested, because it's a contingent unvested future interest, it only occurs if the life tenants die and the remaindermen are still listed on the deed as the remaindermen. But if any of those three things happen while they're on the deed, then their interest in the house can be attached. So the language that I've got, and it should be posted on the site so that you can download it afterwards, is the addition of what's called a power of appointment to the deed. And this is where you're actually going to fill out on the deed, and it's usually going to make your deed a 2-page document as opposed to the normal 1-page deed. You're going to reserve to the life tenants the ability to change their mind anytime they want regarding who gets the house after their death. So all they have to do is exercise the power of appointment. And let's say they have 5 kids and they tell you that they want the oldest son to be the only child that's going to be put on the deed. But then 2 years later, let's say the oldest child is going to declare bankruptcy because he started a business that didn't work out, or, went through the pandemic and it didn't survive. If you know that a remainderman is going to declare bankruptcy, then you would exercise that power of appointment take the oldest son's name off the document and put one of the other kids' names on. As long as you do that at least one day before a judgment is taken, equitable distribution occurs, or somebody files and signs a bankruptcy petition, then that interest is removed before anything could attach to your client's home. So the reason that I sometimes have clients just put one child on as opposed to all of them is I want them to select whichever one of the kids they think is the most financially stable and the one that's most likely to tell them if any of those three things was going to happen, so that the client could exercise the power of appointment. Now we're back then to the problem that I talked about at the beginning, which is now you have a situation where one kid is going to get a non-probate asset, being the house, even though your clients probably have a will that said that they wanted everything to go in equal shares to all of their kids. So again, how are you going to resolve that dilemma? What you do is you're going to have the one child whose name appears on the deed sign a distribution of proceeds agreement. And it's basically just an agreement between the parents and the child that says the child is going to sign it saying, I acknowledge that mom and dad left me the house. I agree that I will place it for sale within 1 year of the date of death of the last of my parents to die. And that once I have received the net proceeds from the sale, I will split it in equal shares with my siblings. And you're going to have all of the parties sign that agreement so that it's legally enforceable, but you're not going to record that agreement in the county clerk's office. It's going to be a private agreement that will be held between the clients and their children so that everybody is on board. Because again, you don't want to be involved in litigation after a client's death regarding what the intent of the testators was, because when they have a will that says that they intended all of the children to receive everything in equal shares, but then they've made non-probate arrangements where assets pass to only one or two of many children, then you have a situation where you have to go back and try to figure out what was their intent. And again, if you can avoid surrogates court involvement in that type of a situation, you definitely want to do that beforehand.
Lisa? Can
Yes.
we just do the course code really quick?
Sure.
The course code today is assets, and I will also put that in the chat to everyone. And Elisa has mentioned her course materials. They are available at the first link that I provided. So if you wanted to look at those while she's talking, they're also there as well.
Okay, thank you.
Thanks. Sorry,
Okay.
Lisa.
It's fine. Some of the other things that I just want to throw out there as good practice tips that I've come across, again, having done this for most of my career. One of the things that can come back to haunt you if you do trust and estates on a regular basis is every time you do a new will for a client, make it a practice of having them sign an authorization so that you can check with the surrogates court in any county they lived in to make sure that there's not an old will already on file with the surrogates court. I made the mistake early in my career of not doing that. You often assume, because most wills say that in the very first paragraph that they are revoking any prior will, that you don't have to worry if there are old wills out there. Well, just as a practice tip, what happens is if you draft a new will for a client and they die, and then you need to have that will admitted to probate, but the surrogates court then tells you that they have an even older will on file, not only do you have to cite everybody that's named in the new will and all the intestate distributees, but you have to then get the copy of the old will, pay for certified copies, and serve anyone who is adversely affected by the existence of the new will. So if you have clients who come in and they're just doing a new will because they're naming, new alternate executors or new guardians or trustees for their kids, always make it a practice to find out if there's an old will already on file with the surrogates court, because you want to get it withdrawn and actually rip it up or physically destroy it, so that you don't have a situation later, or some other attorney has a situation where they've drafted a petition for probate, assuming that the will that they have in their possession is the only will, and then have to go back and amend and serve additional parties because there's an old will on file. So I have one of the paralegals from my office go down to surrogates court every week or two to withdraw any old wills that are down there. And sometimes even when your clients tell you that they never did a will before, there actually are old wills down there. A frequent occurrence that I found are people that actually worked for any of the major corporations that have unions, UAW in particular. UAW Legal Services actually did wills for most of the GM employees and filed those with the surrogates court. So a lot of times those clients tell me that they never did a will, and I actually have gotten an old one out of surrogates court. And also clients that served in the military, a lot of times JAG Corps did a will for them that might be on file with the surrogates court. So I don't even ask clients anymore if they have an old will on file. I just have them sign an authorization, and I check in surrogates court to make sure that there is no will down there. It'll save you a lot of headaches later on. I do want to talk a little bit about two of the other documents that I've also included in the material. I want to talk in particular about the power of attorney. The one that I've included is actually an extended form power of attorney, and it's drafted with many modified provisions. As some of you may be aware, we've had many changes to the general obligations law governing the use of power of attorneys over the last 5 to 10 years. The most recent of which, if you are not aware, is that you no longer have to do a separate statutory gifting rider to give the power of attorney the ability to gift assets. That now is contained in the modifications provisions of a general durable power of attorney. So I do want to talk a little bit about explaining to clients the importance of the power of attorney, because I believe for many clients, the power of attorney is actually the most important estate planning document that you can have. And again, this is one of those situations where you probably are better telling people what happens if they don't have a power of attorney than why they should have one. The importance of the power of attorney is more to avoid having to go through an adult guardianship proceeding, especially if you have a client who ends up needing long-term care or any other type of catastrophic medical expenses as they grow older. The power of attorney is the document, of course, in simple terms, that lets you appoint somebody that can handle your legal and financial affairs if you become incapacitated. But it is a common misconception, especially among the general public, that you have to be incapacitated in order for somebody to exercise power of attorney on your behalf. Many of my clients are surprised when I tell them the power of attorney takes effect immediately, the day they sign it, and stays in effect unless they revoke it or die. And so one of the examples I give, for instance, is if you are a power of attorney for your spouse. And again, many married couples erroneously believe that just because they're married, that they automatically have the ability to sign documents for their spouse, which of course you all know is not true at all. You have to be power of attorney for a spouse. But the example I usually give is, well, let's imagine that you purchased a vacation home in Florida, and only one of you can actually get down to Florida in order to sign the closing documents. Even though both of you have capacity, one of you could fly down to Florida, sign in your individual capacity, and then sign a second time in your capacity as power of attorney for your spouse. It did not require that the spouse be incapacitated. I think many people in the general public are a little bit confused about that point, because we used to have in New York what was called a springing power of attorney that only took effect if the person signing the power of attorney became incapacitated. Those documents are not used anymore for a very practical purpose, which is if you were the person who had power of attorney and you believe that the principal, the person signing it, was incapacitated, and you had to prove to every third party that you presented your power of attorney document to that the principal was incapacitated, you would necessarily have to violate the principal's HIPAA rules and regulations, their rights to privacy of their medical information. Because if you're alleging that the principal is incapacitated due to dementia or senility or Alzheimer's or some type of a physical ailment. In order for you to prove to a bank or a financial institution that your power of attorney was in effect, you'd have to give medical records that are HIPAA protected to the financial institution, which would violate your principal's HIPAA rights. So nobody uses a springing power of attorney anymore. In practice, what happens is you probably should have your client sign at least 2 or 3 duplicate original powers of attorney and give them only to the clients. It should be in your client's discretion whether or not to give the physical document to the person they've named as their power of attorney, because the power of attorney has to have the paper. They have to have the actual paper document to present to a financial institution or a third party in order to exercise power of attorney. And if the principal is the only one that has the document, then they can be sure that there's nobody out there exercising power of attorney without their knowledge. But many times, the other thing that happens is I get told by financial institutions many times that the power of attorney that the agent, the person who holds power of attorney has presented is not acceptable to them. And that gets interesting. The reasons why they decide that the power of attorney is not acceptable. I've been told, and by the way, none of these are true, but I have been told on many occasions that a power of attorney is no longer acceptable if it's after the date that the notary stamp expired. And so, which all of you know is not true. The notary stamp would, as long as it was in effect the date that the power of attorney was notarized, it does not matter at all whether or not the notary stamp is expired when the power of attorney document is presented. I've also been told that the power of attorney is too old, that I needed to get a new power of attorney because the power of attorney that my agent presented to the financial institution was more than 2 years old. Well, of course, if it's a general durable power of attorney, it never expires unless the person revokes it or dies. So what you should do in those instances is keep a copy of the general obligations law that if any of you have the green book, you can just make a copy of the pages. It's actually a criminal offense in New York State for a financial institution or a third party to refuse to accept a properly executed power of attorney. So many times we end up having to scan that and send it to the offices of counsel at various banks or financial institutions to get them to accept the power of attorney, because they come up with these reasons why they say that they can't accept them. But let's talk a little bit about why you should have that power of attorney. If you need to do Medicaid planning for someone, if you're going to try to get Medicaid to cover long-term care services, one of the things you absolutely have to have is a power of attorney that has the ability to give that person's money away. And in most cases, they need to be able to give that person's money to themselves. And that's because most people name an adult child as their power of attorney. And if they were going to give money away in order to qualify for Medicaid, it's probably the adult children that they would give it to. And if you don't have a power of attorney with statutory gifting provisions in it, your only other option is to go through an Article 81 adult guardianship proceeding under the mental hygiene law to have a Supreme Court justice declare your client to be incapacitated. And then you would have to do a separate petition asking for the ability to do Medicaid planning. And so now this is not a seminar on Medicaid planning. Of course, that's another seminar and topic that I can talk for hours about. But I do want you to have just a general understanding of what kinds of things can be done, because many clients that come into my office don't even know that the New York State regulations with regards to Medicaid eligibility do allow gifting of assets in order to qualify for long-term care. In New York, we are not one of the states that has what's called a recoupment statute. Many, many states other than New York have laws that say if a person needs Medicaid as they grow older, and they have given away any of their assets in the 5 years preceding a Medicaid application, those states can go after the recipients of the gift, which are usually the adult children, and try to get it back. And it depends on which state you're in, because every state has their own regulations. But many states will go after adult children or grandchildren that have received monetary gifts in the 5-year look back period. That's the 5 years preceding a Medicaid application. And they will try to get it back. New York does not do that. All that happens in New York is if you have a client that has given some money away in order to try to qualify for Medicaid, and it doesn't matter if they gave it away today or yesterday or a year ago or 4 years, 11 months and 29 days ago, if any gifts at all were made in the 5 years before a Medicaid application, all that New York does is calculate how many months they think the person could have paid for their own care if no gifts were made. And they impose that penalty period. And it's really easy to understand if you just use a simple example. Let's say you had a client that gave away a total of $120,000 over the last 5 years. New York would not try to get it back. They would tell that client that $120,000 would have covered about 10 months of care. And they'll say to that person, we're not going to try to get it back for you. If you want to try to get the money that you gifted away in the last 5 years back, try it yourself. We're just not going to pay for the first 10 months that you need long-term care. We'll start to pay in month 11. And so what all elder law attorneys in New York do is we use a variation of what's usually called the rule of halves, or the half a loaf theory. We give some of the person's money away. We accept the fact that we're going to incur a penalty period. And then we loan one of the adult children enough money to cover the penalty period. And so in New York, it's very common that you're going to need the ability for the power of attorney for the incapacitated person who is in need of long-term care to have the ability to give money away. In New York, it's a little bit complicated mathematically, but you can always give away at least half, and many times much, much more than half of a person's total net worth in order to qualify them for Medicaid. So it's very important, if you're doing a power of attorney for a client, that you have the provisions in the power of attorney document that allow the fiduciary, the agent or the power of attorney, to give the person's money away in addition to being able to buy them things or pay their bills. And so I have included in my documents that are on the website all of the modifications that we use as elder law attorneys so that our clients can do that type of planning. But you're free to choose and pick among all the different modifications or to draft your own. The statute is very clear that you can pick and choose among the modified powers that you want. The only reason that I emphasize this so much is because many times clients come into my office with a power of attorney that was done by an attorney who is just a general practitioner and not an elder law attorney. And they specifically did not initial the provision in the statutory form that allows gifting. And that puts us in a position as elder law attorneys where now we have to go through an Article 81 proceeding. And so if you don't know the reason for the statutory gifting provisions, you want to at least make yourself familiar with the reasons that a client might want to give their power of attorney the ability to gift assets away. The last form, really quick, I know we're going to try to leave some time here for some question and answers, is the new healthcare proxy and living will. That document has changed many times. The most recent changes were in October of 2017 when they had to become MOLST compliant. So MOLST is our new medical orders for life-sustaining treatment law. And basically that law says that if a person wants their healthcare agent to be able to obtain a do not resuscitate or a do not intubate order, they have to put in writing under what conditions they would allow it so that their healthcare proxy can request it. Those conditions in New York State under which a DNR or a DNI can be put into place would be if the principal, the person who is signing the healthcare proxy, is either in a persistent vegetative state, a coma, diagnosed with a terminal illness with less than 6-month life expectancy, or diagnosed with some other debilitating illness from which recovery is unlikely. So you want to make sure when you're drafting your living will provisions for a healthcare proxy that you're including that ability for an agent to request and receive either a do not resuscitate or a do not intubate order. You also want to talk to the clients about whether or not the healthcare agent is authorized to make a tissue or an organ donation. So I usually just ask my clients whether or not they already have the red heart on their driver's license, or if they're interested in having that provision included. I do not make it mandatory. It does not say donate my organs or tissues. It says my healthcare proxy has my permission to authorize a tissue or organ donation if they think it's appropriate. So you can, I've included that form too, and you can look through the various provisions in the living will portion and modify those for your clients' wishes as well. I think that I've got about 5 minutes left. I don't know if we've got anyone that's got some questions that I could answer.
Hey, Lisa, it's Earl. We don't have any questions currently in the chat, but if anybody currently in the program wants to throw a question in the chat, I could present it to Lisa and she can answer it, or if you know, we could try to take you off mute and ask the question yourself.
Okay. Well, then the last thing, if I've still got some time to just wrap up, I also included in my materials the Medicaid eligibility guidelines for 2022. There should be 2 documents there. One I call my cheat sheet, which is just the numbers for 2022, the spend down numbers, the allowances for resources and income. And then there's a longer explanation that's written for clients regarding what happens if you need long-term care. And so I know that other attorneys have used these forms, and you have my permission to give them out or use them to help explain to clients what happens in that situation. I do want to emphasize, though, that you must keep them current, because every year the Department of Social Services changes all of the numbers. They change the resource allowances, they change the income allowances, they change the allowances for the community spouse. So it is important that if you're handing out those particular documents on how to get eligible for Medicaid long-term care benefits, that you update them every year. This year, if you're a single individual in need of long-term care and you want Medicaid assistance from New York State, your resources have to be below $16,800. And if you have a community spouse, they have an additional allowance, which is actually between $74,820 and $137,400. The actual rule in New York State is that a community spouse gets to keep half of a total net worth of a couple, but it can never be less than that $75,000 figure or more than the $137,000 figure. And so I find those documents are a little bit helpful just in giving people an overview as to what they could expect if they needed long-term care. Many clients think that Medicare covers long-term care. And so you want to disabuse them of that notion if they're relying on Medicare, because Medicare will only cover long-term care in situations where it's a rehab placement for a short term only. So for instance, if you have a client who falls and breaks a hip, Medicare will pay at most days 1 through 20 in a rehab facility, and then perhaps an additional 80 days, but those last 80 days would have a fairly high copay. And in practice, Medicare never covers that.
Sorry to interrupt. You have a slew of questions that have popped up in the chat. We're almost at
okay.
time.
Sure.
The first question is from everyone's favorite real estate lawyer, Neil Pulowski, and he wants to know, how does one exercise the power of appointment on the life estate deed? Do you record the exercise with the clerk's office?
Yes. So what we do is another deed in the same format as the initial one, saying that the grantors intend to exercise the power of appointment to replace the remainderman. And then we simply state that we are removing child X and that the new remainderman is child Y. And yes, it does have to be recorded. And so, of course, if it's in Erie County, you're going to pay another $190 filing fee to do that.
Okay, great. Heather Gresham has asked about the POA. Is there no springing option any longer? You recommend that the principal retains the POA until they want their agent to exercise their authority.
Correct. I don't believe that the springing power of attorney has formally been revoked by the legislature. I think it's still a form that's out there. In practice, though, it would be very difficult to use it. As I said, you would have to violate your principal's HIPAA rights in order to prove to any third party that you were presenting it to that you actually had the ability to act. Because in order to prove that someone's incapacitated, you necessarily have to provide their confidential medical information to third parties. So I just think in practice, no estate planning attorneys use that springing power anymore.
Okay, great. And then there's one more question. Can you provide a sample provision giving the executor the discretion to take into account non-probate, that the non-probate accounts are intentional gifts separate from the will? And it's a two-parter. Would you clarify, would you put those provisions in the will or only in the distributed agreement you discussed? The three-parter, actually. Do you have the parents and all the children sign the distribution agreement, or just the child who is on the non-probate asset?
Okay, I have all of the parties sign that. It's a separate document from the will. However, I will put in the will on many occasions that, especially if I know that they've already made non-probate arrangements that benefit one or more of the children, it never hurts to put right in the will, I have made arrangements during my lifetime that some of my non-probate assets will pass to certain of my children. Because then you have it right out there in a document that will hopefully prevent any contested estate litigation at a later date. But again, people change their minds about how they want their assets distributed during their lifetime. So you don't necessarily want to list specific non-probate arrangements that have been made in a will. So I normally will just put in a provision that says that they have made arrangements that certain non-probate assets will pass outside of the will. The distribution of proceeds agreement, which I do in connection with the deed transfer with the retained life estate, or the separate distribution of estate proceeds agreement, is a document that I keep and I give copies to all of the parties, but I generally have all of the children and the parents sign those documents and notarize it. And I can get you an example of one. I'll mail that in and have that posted later on today.
Fantastic. Thank you so much, Lisa. Our time has now expired. I'd like to thank each of our sponsors and our speaker, Lisa Allen, for her time and insights. Everyone, please be sure to send in your attorney verification form and program evaluation to Michelle Miosi so that we can issue your CLE certificate. And be on the lookout for future Law Alumni Association CLEs and programming. And if you haven't rejoined, please rejoin. We'd love to have you as members and provide you with that free 1-hour CLE.
Well, thanks for having me today.